For those of you who know me, I am a former teacher that is now completely against public schooling of any kind. It has become a toxic environment which promotes conflict, liberal ideology, radically altering history lessons to brainwash children to hate one half of the country. And don't get me started on the gender-neutral locker rooms and the litter boxes for kids that identify as cats. I wrote several papers for my master's degree on the problems with public school, including my master's thesis which showed how taxpayers are being overcharged billions of dollars a year for glorified babysitting. So first things first, when it comes to custody battles, schools favor mothers. The overwhelming majority of public school administrators and teachers are leftists. Facts should never be left or right or have a political slant. If we are to teach children to think for themselves, bias should play no part in education. But not only do schools generally favor mothers, but if your child goes to school in the school district where your ex lives, schools will actively support the mother to keep the public funds flowing. It is often why, even in 50-50 custody decisions, that mothers are awarded the right to make educational decisions. It is all part of the system to build an army of allies for the mother in the custody battle. Keep in mind, mothers are responsible for 60% of all child abuse, and are more likely to kill their children under the age of 7 years old. Yet the amount of support they receive is absurd and politically motivated. When my daughter was in elementary school on my days, I would pack my daughter a healthy lunch with a sandwich, fruit, and a drink. On her mother's days, she would rarely even give her anything. Schools get public funding for the school lunch program if, and only if, the student takes the lunch from the cafeteria lady. Doesn't matter if they eat the food or not. And let's be honest, the crap they serve at school lunches in the US is terrible. So generally, when I would pick up my daughter from school on my visitation days, she hadn't eaten lunch or breakfast, and most of the time hadn't showered or changed her clothes in a couple days. I brought this up to my daughter's teacher, who kept an eye out for what my daughter would eat on my days versus her mother's days, and also about her hygiene. The teacher did notice an issue and sent a letter home addressing both issues. Two days later, the female school principal intervened and told the teacher not to get involved because it was just a custody dispute. From my perspective, neglect is a serious thing, not just reduced to merely a custody dispute. This prompted an argument with the school principal and their duty as mandated reporters to file a report with the state. The school principal stated that as mandated reporters, they have discretion as to what they feel is abuse or neglect, and can make that determination after their investigation. Keep in mind, mandated reporters do not have discretion, and they are not to investigate, acting as judge, jury, and executioner. It's the role of Child Protective Services to do this. Based on our argument, the school principal decided to force my daughter to take a school lunch and told her she couldn't go to recess until she at least ate something from her tray. I was livid, but not many options existed at the time. So here is what I did. First, I filed a Child Protective Services complaint against the school and brought it to the attention of the superintendent. Child Protective Services also stated schools don't have discretion and should not be investigating what the legal definition of child abuse and neglect are. Second, I filed another complaint against the school for fraudulently counting school lunch numbers to get additional state and federal funding. Even if it didn't prompt an immediate investigation, it put the school district on notice that what they were doing could eventually get caught. Third, I then emailed the law on mandated reporting to both the school principal and the superintendent. The superintendent responded that generally Child Protective Services didn't do anything, so it was rare that they report anything. While all of this was going on, two other things were happening. My 7-year-old daughter was getting dropped off the bus in the middle of winter, 30 degrees outside, no key to the apartment, and her mother was not home. This was happening the majority of her days, where my daughter would be stuck outside in the cold for an hour before her mother would come home. Again, this is neglect and putting her in a dangerous situation. I filed another complaint with the school which did absolutely nothing, taking no responsibility for the issue, stating that as soon as the child exits the bus, they have no duty to the child. So I started filing Freedom of Information style requests for documents about my daughter while at the school. Similar to doctor's notes that patients don't generally read, schools have communications, often emails or chat messages, between the teacher, school counselor, and the principal about your child. Since I was a teacher at the time, I knew their tricks to circumvent parents getting access to this information, so my requests were very detailed. If you ever want to gain access to these behind-the-scenes notes, do the following. First, schools will generally not use your child's full name in behind-the-scenes messages. They will use variations of her name with initials. As an example, we will use the name John Doe. Different variations that might be used are J. Doe, John D, JD, or they may even refer to him under a nickname. So if some of your family members call your child Johnny or Jack, you need to add in those variations to the request as well. Second, you need to add in a statement that says you are requesting all communication between school staff officials, including teachers, counselors, and principals, among themselves and with outside individuals, including parents, family members, therapists, etc. They will limit your information if your request is vague. Third, the request must be in writing, and I do like to send it certified mail just in case there is ever an issue. What I found from my information request is that the school was actively working against me, making allegations that my daughter was only anxious, distracted, and seemed depressed on days when it was my visitation, so she must not want to go with me. This is all while my daughter would purposely try to get sick and tell her mother she wanted to stay with me so I could take care of her. I also learned that my ex was actively engaging in character assassination again to build her wall of allies. At one school function which I brought my daughter to, her mother showed up, grabbed our daughter by the arm, pushed her up against a wall and started yelling at her because she refused to talk to her. School officials were right there when it happened, yet said they investigated, no one saw anything, and that my daughter must have misinterpreted the interaction. Again, I was livid. The people who are supposed to protect and educate children were actively trying to protect a child abuser. Within a year, I was able to successfully obtain a protection from abuse order on behalf of my daughter against her abusive mother. However, the court set up provisions on how my ex could get supervised visitations with very low requirements for those supervised visitations to begin. They asked specifically who she would feel comfortable with as the person to supervise the visitation. Let me say this another way. The abuser gets to choose who she feels comfortable with as the supervisor. Absurd. But she mentioned the school principal in the hearing as being an ally who said she would function as the person who supervised the visitation. In court, I objected on the grounds that it created a conflict of interest since school officials are government employees. Of course it was overruled and the judge actually liked the idea, but I had another trick up my sleeve. As soon as I received the actual order, I forwarded the order to the school principal to make sure she knew that my ex had no access to pick our daughter up from school or have contact with her until she satisfied the requirements to get supervised visitation. Then I asked the school principal when she would be available to do the supervised visitation. The school principal was confused, so I responded back that according to court record, you have been helping my ex get custody, and that she named you as someone who told her you would function as the supervisor of the visitations. If this isn't correct, please let me know so that I can find someone else. I then forwarded the email to the superintendent of the schools and asked him if he was aware of the principal actively helping an abusive parent to get custody of their child and functioning outside of her duty as principal to conduct the supervised visits. While the superintendent never responded to the email, the principal kindly emailed back stating that she couldn't function as the supervisor of the visits, but she would make sure my daughter was protected per the court order. Oh, how I wished I could have been a fly on the wall for the conversation between the principal and the superintendent. Boom! Not only was this a slap in the face for the principal, but it discredited my ex, and I am sure the superintendent must have told her to back off. Otherwise, it was opening up a potential lawsuit situation. Then, a month later, the school year ended, so I moved my daughter into the school district near me. This was also the school district I was working for, so I had additional protections in place. So guys, we know the system is rigged. You have to arm yourself with knowledge and understand who is working for you or against you. Then, like a sniper, learn to take them out of the equation to level the playing field. Information requests and filing complaints that could affect their funding are definitely tools I would use. But otherwise, if you can get your children into homeschooling groups, where they can still socialize with other children too, it's well worth it. The next video is how I took out a corrupt therapist. Don't forget to like, subscribe, and share. And remember, stay safe, stay strong, and stay vigilant.